Which one are we ready on?
We're going to do Syed LV.
This is docket 256690 FH, People of the State of Michigan versus Syed Alvi. Counsel, your appearance for the record.
Good morning, Your Honor. APA Bar Buxton on behalf of the people of the state of Michigan.
Good morning, Your Honor. Attorney Scott Grable, P53-310, on behalf of Mr. Alvi, who's here to my left, Your Honor.
Thank you. If you could come up to the podium with your client, that'd be appreciated. Thank
Sure,
you.
Judge. Sorry about that.
And that's okay. Other side. Other side. Yeah, thank you. It's just for the ease of getting everything done. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury? Thank you. Put your hand down. Have you taken any medication yesterday or today?
No.
Are you supposed to be on medication you're not on? Any sign of fever, COVID, or other illness?
No.
And you've had an opportunity to speak with your attorney? All right, thank you. This is a final pretrial, but I also do have a defendant's motion to dismiss. You're looking for a court date?
Yes, Your Honor. I have spoke to Mr. Buxton. If the court has September 24th available, I'm on vacation, part of September. We would have filed this brief earlier. I want to let the court know we were waiting for a Supreme Court opinion that came out 7/31 on People v. Jade, which our firm argued. It was an entrapment case. I'm sure the court may be aware of it, but we really couldn't file it before. So I don't want the court to think this was filed at the last minute. We prepared it. As I said, he's been served a copy of it. So that's what the late date is. It is scheduled for trial on September 25th. It's very low on the priority list, Your Honor. I may ask the court to move it. I think there are cases in custody that appear there's a high probability they're going to go anyway, but I wanted to bring that to the court's attention of why it's being filed at this date as opposed to a month or two ago.
Okay, and so you're asking it to be heard on the 24th?
Yes, Your Honor, if that's acceptable to the court, September 24th, yes.
I don't know. How much time do you think this will take?
There may be some stipulations, Your Honor. I would ask the court to block out 2 hours. What do you think, Mr. Buxton, just to be safe? And I'll try to make it as efficient as I can. There was a lot flushed out there in the preliminary exam, but for the record, I want to make sure we make a thorough record.
And for the record, I agree with that.
I need a 2-hour block for evidentiary hearing on a motion to dismiss, and I need it's on docket 256690 page. Alvi, Syed Alvi. They're asking for September 24th, which is Thursday, for a 2-hour block. I don't know, because we're in trial. Does that work, or do we have another date? Okay. Okay. All right, let me see. Would you like 10 o'clock, like 10 to 12, or would you like 1:30 to 3? Well, do we have weapons? Oh, no, that's.
What's your preference?
Typically, Your Honor, I'm always concerned about officers working the late night shift, so I would prefer the afternoon.
All right, 1:30?
I'm fine with that, Judge. That's fine.
1:30, September 24th. Okay, thank you. And on behalf of the people, you'll be filing a responsive brief?
That is correct, Your Honor. The people just received this motion earlier this week. We are working on that right now.
All right, and this was the date set actually for the final pretrial. Should we also move the final pretrial to that date?
That would be fine, Your Honor.
Okay,
Thank
And
you,
then we
Judge.
can get a new trial date if we need to at that point in time.
so we'll have the final pretrial and the motion to dismiss September 24th at 1:30.
Thank you, Your Honor.
And then if for some reason a key witness can't be there, you can call my office and move it. All right, obviously we don't have control over some of the witnesses, officers and what have you, so you can move it with Nicole, not me.
I appreciate your honor. I'll do that. Mr. Buxton, I did give him a list of the witnesses that I'd like available, so he's aware of that. I'm sure he's working on it as well forthwith. I've already supplied those.
All right, bond and bond conditions are continued then. Is there anything we need to address?
I would very briefly, and I told Mr. Buxton I might address, the client is right now out on a personal recognizance bond, your honor. There's been no conditions. He's reporting the pretrial services as you would expect, since bond is obviously a privilege. He has not had any issues. He is under, even though he's a medical doctor, he's under supervision of his mother. There's been no issues with that. That was something Judge Allen wanted to do, which of course we weren't opposed to. The one issue I'd ask the court to consider modification is he's on a GPS tether. I could certainly understand the purposes of a GPS tether under certain circumstances. In this particular case, your honor, as I said, he's been out on bond approximately 6 months. I don't speak for Judge Allen, but I think the purpose wanted to make sure there was going to be no issues. He surrendered his passport, no criminal history as the court would expect, no juvenile history. Obviously, these are serious charges. I'm not going to suggest, but purpose of obviously the GPS, the court knows what the purpose of that is. I don't need to remind the court. And I wouldn't make the representation of the court. I'm confident there's not going to be any issues with the tether at all. The issue is right now he's not working, obviously, since this case is pending. Sparrow has terminated his services. I understand what that is, but the court knows he's presumed innocent. I don't think really the GPS tether, it cost almost $300 a month. It's a hardship, your honor. Obviously, he has to procure that money from his family. I don't think in this specific case, even under the specific facts, I don't think a GPS tether really advances the safety of the community, or he's a flight risk. That's the only reason I'm asking the court to keep all other terms and conditions in place. I would just ask the court to discontinue the GPS tether. I don't think it really, in all due respect, doesn't effectuate really any more safety component to the community. Obviously, the client understands if you have police conduct or any improper behavior, he understands, your honor, he'd be sent to jail. So he's intelligent enough to understand that. I'm not going to go into the virtues of the success and merits on the entrapment motion. I'll just say I only mention as a factor of bond. I can assure the court it has absolutely substantial merit, or I wouldn't have filed it. And I don't make that statement lightly. But again, unless the court has inquiries about the tether or anything else, I would ask the court at least just modify the bond only in reference to the tether. He continues to report to pretrial services. All other terms and conditions we would certainly ask to remain in full force and effect. Thank you.
Any objection on behalf of the people?
Your honor, due to the charges and the alleged allegations of Mr. Alvey attempting to make contact with a 15-year-old for sexual acts, the people do believe that would be in the best interest of the community and as a safety for the community for Mr. Alvey to continue to be on GPS tether. Thank you.
All right, sir, I'm removing the tether. However, all other terms and conditions in regard to bond will remain in effect.
Thank you, Judge.
I'm going to give you a copy of this order.
Yeah, I did.
Just wait a moment, we will get that to you and I'll see you on the 24th.
Thank you, Judge.
Thank
Appreciate
you.
your time.
I'll just take a moment to get that to you. Next matter.
Yes, your honor, we're gonna do Eric Campbell.
This is docket 26446 FC, People of the State of Michigan versus Eric George Campbell. Counsel, your appearance for the record.
Good morning, Your Honor. Andrea McCray, appearing on behalf of the people.
Your Honor, Jeffrey Kaplan, P 74943, on behalf of the defendant who's standing to my right.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, sir.
Thank you. Put your hand down. Have you taken any medication yesterday or today?
Yes, sir.
Is it anything that would interfere in your ability to understand the court or your attorney? Is there medication you're supposed to be on that you're not on?
Say that again, ma'am?
Is there medication you're supposed to be on that you're not on?
No.
Any sign of fever, COVID, or other illness?
Didn't get that one.
Any sign of fever, COVID, or other illness?
No.
Do you have trouble hearing?
I'm hearing you now.
Okay, because we do have some headphones that would help.
Okay, I'm hearing you.
All right. And sir, have you had enough time to speak with your attorney?
Were you talking this morning?
Okay, did you need more time with him?
No, we're good.
Okay, I understand this is a final pretrial. Has there been an offer?
Yes, Your Honor, the offer in this case would be for the defendant to plead guilty to criminal sexual conduct in the first degree. There would be a sentence agreement to a fixed minimum of 14 years in the Michigan Department of Corrections. The people would dismiss the balance of the information.
So that would be the CSC count 1,
Yes, Your Honor.
and then counts 2, 3, 4 would be dismissed?
Yes, Your Honor.
Thank you.
And 5.
Is there a 5? Maybe there's an amended information I just
I'm
have.
lawful imprisonment.
There is, yeah, so it's just all other counts would be dismissed. It would be a pleaded count 1 and all other counts which would be,
Okay, and count 5, okay.
yeah.
So
counts 2 through 5.
2 through 5 would be dismissed. Is that full, fair, accurate, and complete?
It is, Your Honor.
Sir, is that full, fair, accurate, and complete? That was the offer that was conveyed to you?
Yes, ma'am.
And counsel, will this be a trial or is he accepting the offer?
It will be a trial, Your Honor.
All right, and sir, you understand, so this is a final pretrial, we're gonna move it then to trial. I generally don't allow offers in between, and that's because we need to get you to trial. And if you decided to plead to accept this offer on the day of trial, someone else would lose their right to a trial on that day. So we keep the docket moving this way. Do you understand?
Yes, I understand.
Okay, so did anyone force, threaten, or coerce you to make this decision?
Deny the offer.
I'm sorry?
Did
You're
anyone
denying,
force-
sir,
No.
you're denying the offer, but I need to ask you some questions about that. We're gonna get you to trial. Did anyone force, threaten, or coerce you to make the decision
No,
to
ma'am.
decline the offer?
No,
Has anyone promised you anything that caused you to decline the offer?
no.
You made this decision after you talked with your attorney,
Yes, sir.
and you've been satisfied with his representation?
The last part?
You've been satisfied with his representation of you thus far?
I will say for him, Your Honor, that there have been issues.
Okay.
And I did talk to his son and his wife this morning, or his ex-wife. I think, and I learned this from talking to his ex-wife, my client's native language is Jamaican patois, which I didn't know was a thing, to be honest with you. And she suggested that I get a Jamaican interpreter, which is something that we'll probably need for the trial as well.
If we need it for the trial, we need it for today. We have to redo this. I
Your Honor,
can't.
and if I may, I believe at preliminary examination, the defendant did have an interpreter present. So I was gonna suggest that we have a different trial date anyways, because the trial date we currently have, we're not going. It's just, we're so far down the list. And so I was gonna suggest possibly that we do another final pretrial on October 14th, 2026, and a trial November 13th, 2026.
I'm sorry, November what?
13th.
13?
And that way we can, have an opportunity for the court to get the interpreter for.
Okay, and what is it, Jamaican what?
Patois,
How do you spell that?
I believe it would be Patois.
Okay. This should have just been reset. Okay, sir, we're gonna get you a new date with an interpreter, okay?
Thanks.
Do you understand what I said?
I
Okay,
understand what you said.
so
So
we're gonna go through all this again.
thank you. And we did need to go on the record for one other thing, which is why I didn't just schedule another date. But can you give me the final pretrial date again?
October 14th, 2026, and what time is that?
9 a.m.
9 a.m.
And the new trial date?
November 13, 2026, 9 a.m.
Thank you.
And what else do we need?
Well, there's the issue of bond, Your Honor. My client has been held since January 7th of 2026. My notes indicate that he's being held without a bond. If that is correct, Your Honor, then this court needs to establish a bond. He's been held longer than 90 days at this point without one. And of course, this is falls under 6.106B3.
All right, let's address bond, although I'm a bit uncomfortable doing it without the interpreter, but it is his right to have one, so let's do that. And then if we need to go back on the record when we get an interpreter, we will do that. So, because I tend to agree with you, I don't know why this wasn't brought before me, I certainly have had time to hear this. So, half the people in regard to bond.
Your Honor, we would ask for $1 million bond. This defendant had to be extradited from Jamaica because he fled from the country after this offense occurred. We actually had to work with the FBI, the Department of Justice and Homeland Security to secure him in that other country to get him here so we could prosecute him. The victim testified at preliminary examination. She was incredibly credible in her testimony. She gives very specific details about being in the defendant's home, which were corroborated by photographs of the defendant's defendant's home, not phone. There's a very high likelihood of conviction here. And also the fact that he fled. This offense occurred, Your Honor, in 2013. And he, right after police did a search of his home, fled the country, which obviously will be it goes to consciousness of guilt, and his state of mind, and having a guilty state of mind. For all those reasons, Your Honor, we'd ask for $1 million bond. Thank you.
Response?
Thank you, Your Honor. I did talk to his son and his ex-wife this morning, and they have informed me as well that my client didn't flee the country to avoid this. He fled the country. He left the country to go back to Jamaica because his brother was terminally ill. And he went back to Jamaica to take care of his brother. My client still had a Jamaican restaurant that was here that he intended to come back to. His brother lingered for a long time. His son managed the restaurant while he was gone. And his brother ended up holding on for a few years before he passed away. And at that point, my client was entrenched in life in Jamaica and stayed there. He waived his extradition hearing to come back and address this. He has a place. He doesn't have any prior criminal history that I know of here. We don't have any records from Jamaica, but when he was arrested on this warrant, he was not arrested for any other criminal activity that I'm aware of. He has a local address. He can stay with an individual by the name of Jacob Jesse at 2331 Nob Hill Drive. That's apartment 6 in Okemos. So he has a local address, Your Honor. As to the strength of the case, I think the testimony, I sat through the exam, even though I didn't conduct it. And having read the information, the evidence was that my client was assisting this girl with travel so her mother can get to dialysis. And then she went into his house. He drove her back to his place. She went into his house voluntarily. She went upstairs voluntarily. What happened up there is an issue of dispute. But my client, again, as far as I know, has no prior criminal history. So we're asking for a low cash bond. I know the seriousness of the charges here, Your Honor, but we would ask for a $5,000 cash or surety bond. If he's able to get a bondsman, I think that that will ensure my client's appearance. I should note, because this has been an issue, my client is a United States citizen. His ex-wife tells me he has dual citizenship. My client tells me that he was naturalized here. So if he is released, I don't believe and would not expect a detainer because he has been naturalized here. We did have a copy of his passport that was sent to us. I haven't forwarded it to the court, but our investigator did try to verify that by getting his ex-wife's in Tennessee. That's why we don't have ready access to it. But they did provide that, and I can send that to the court where it wants requested.
Anything you want me to know, sir?
No, ma'am.
I would agree, given the severity of these offenses. There are 3 allegations of criminal sexual conduct, first degree, punishable by life, assault by strangulation, a 10-year felony, and unlawful imprisonment, a 15-year felony. There are only allegations. He is innocent until proven guilty beyond a reasonable doubt. However, public safety and the safety of the victim is a concern. The issue of extradition is also a concern. While I appreciate your argument, counsel, the issue is that this happens in 2013. 13 years later, we have to go get him. He doesn't show up, doesn't even visit here for us to get him or to answer to these. So it will be $1 million bond. I've noted that he's a flight risk due to extradition, and that bond will not, it will be a cash bond, and that will not be given until there is address verification. He'll check in with pretrial services weekly and have a jail GPS tether, and he will not have any contact with any victim or witness, and certainly not Tanisha, Tanashia Fletcher Perkins. He would maintain that residence, and I would not allow any address change. That would have to go through the court. And he'll not use, possess, consume, or be in the presence of illegal drugs, alcohol, or drug paraphernalia. And he would show any prescriptions from a licensed medical physician to pretrial services within 24 hours. He'll not have in his possession or under his control any weapon, gun, ammunition, or imitation of a weapon. He'll not be in the presence of anyone who has those items. And he will turn over, if he is released on bond, he will turn over his passport, and INS will be noticed not to reissue a passport until this matter is resolved, because we have had instances where the court takes the passport and then someone just claims it's a lost passport, they get another one. So INS would also have to have notice. We'll give you a copy of this, and if you want this further considered, please prepare a bond report and have the translator present. So if you want to redo this, we can do this later.
Thank you, Your Honor.
But that's what it stands today. Thank you.
Yes. Your son was here earlier. I talked to him. I don't know why. Oh, he's there.
No,
Oh, yeah, we don't have to bring them up. Can we have Christian brought up?
No, Reichstetter as well.
And Reichstetter, please. Reichstetter?
Can you bring out Jones? You play Sean Jones next? Pretrial slash bench warrant arraignment.
This one, there's, on my schedule, it's on page 3, but then there's also some on page 5, it's the same.
Yes.
Attorney,
Oh, stand on the other side.
I didn't look if they were all the same.
Who is, I'm sorry, who is it?
Oh,
Clayshawn Jones.
Okay. And then. I want to check the files, I don't know, I have
It seems like it's just 2 files.
2 files.
But
it's
it's
two, yes.
with different pages, so I don't.
So we have a pretrial and an arraignment.
Correct. It's a bench warrant arraignment.
Okay. We just need a moment, she's done with the files.
No problem.
All right, this is docket 26-3512 FC and 26-3522 FH. People of the state of Michigan versus Clayshawn Jones. Counsel, your appearance for the record.
Good morning, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan.
Attorney Luke Goodrich from the Public Defender's Office, here to represent Mr. Jones, who is standing to my right.
Please raise your right hand. Do you swear or affirm the testimony you're about to provide to be the truth, whole truth, and nothing but the truth under penalty of perjury? Thank you. Put your hand down. Have you taken any medication yesterday or today?
No, ma'am.
Are you supposed to be on medication you're not on?
No, Your Honor.
Any sign of fever, COVID, or other illness?
No.
Have you had enough time to speak with Mr. Goodrich?
Yes.
And we have an arraignment on one file, and the other one is what, a pretrial?
It would be on both, Your Honor. Both apply to both files.
Correct.
Okay. So the bench warrant that I have on each says, sir, that you were on bond conditions and you were not to have any firearms and you were in possession of firearm and ammunition. Now, are there new charges from this?
There are not at this time, Your Honor.
Are there going to be?
The people have not received a police report or anything in regards to, from the police in regards to requesting charges.
And Your Honor, I would also say that I don't, from everything I've heard, which is limited by the fact that we don't have a report, is that there was no gun found on Mr. Jones. There was a gun found in the house he resides in. Other people reside there too. I don't know if there's any actual tie to Mr. Jones.
Okay. Well. I hate to have him plead to this and then we have subsequent charges. So I'm gonna hold these in abeyance. So let's talk about where he's living and what's going on with weapons in the house. Can those all be removed?
Your Honor, it's mentioned he lives with his mother. I know he has, an older brother and others who stop into the place. If I could. Your Honor, I will contact his mother about making sure that any other potential firearms are out of the house, even if they're legal and they're hers, or, I don't know who any of this stuff belongs
Either
to.
that or he has to move to a place that
Okay.
is approved by pretrial services and where there are no guns, or ammunition or contraband, illegal drugs, etc. Because on docket 263512 FC, the charges are count one, armed robbery, which is a life offense, weapons felony, firearm. And then we have docket 263522 FC, weapons carrying concealed, a 5-year felony. So there is a concern about him having access to weapons regardless of who has them. So he either has to move to an environment, a location where there is no weapon, gun, ammunition, or they have to be removed immediately from his home. Do you understand that, sir?
Yes, sir.
Okay, so I'm withdrawing and dismissing both bench warrants because of the circumstances. However, sir, if you are found with more weapons, there'll be no bond, no release. You'll just sit in jail. You're pending a life offense. So I need everything complied with 100%. Do you understand?
Yes, sir.
So how many days has he been in jail?
I believe this is 8.
So he gets 8 days with credit for 8 days on each file. And then, was he on a tether?
Yes.
So he'll just be released, on that tether with all of the pretrial conditions. Is there anything we need to add, or do people want to add anything in regard to this?
Your Honor, I understand that you wish to let him out on a PR bond. The people are concerned that this is now the third alleged offense that he has firearms. And the first, as you had stated, is an armed robbery. So the people are concerned about public safety if Mr. Jones is let out, and will be able to potentially get more weapons, Your Honor. So people are just concerned. People would be asking for a 20,000 cash surety bond.
Counsel?
Well, Your Honor, I would, if the violations in this matter have been dismissed at this point, I would just ask if the bond be reinstated, with the tether, essentially as they were.
Sir, I'm gonna reinstate the bond with the tether. Go ahead, make my day, violate the law. And then I have these big court rules that say, and lots of case law that says I don't have to give you another bond. So you will sit in the jail until we have resolution and we go to trial. And you have a 26 case. I got the person who is in front of you today, he has a 13 case. So he's like my number one case. I have a lot of 24s and 25. So you could be sitting there several months, maybe a year, without bond because of your behavior. So if you want out and to stay out, you need to be the most law-abiding citizen we have. If you want to be in that jumpsuit and have the sheriff babysit you, have 3 hots and a cot, go ahead, break the law. Are we clear?
Yes, sir.
Are we also clear, no contact with any witness or victim?
Yes, sir.
Are you working?
Yes.
Where do you work?
Brushman LLC in East Lansing.
What is it?
Brushman in East Lansing. It's a
Brushman?
paint job for MSU.
Painting?
Yeah.
Okay. You go to school?
Yeah, I'm online right now. I'll be finishing this year.
Okay. Well, then get to your studies, work, go home, hang out, watch TV, play computer games, do whatever it is you do. No weapons, no more crime. Got it?
Yes, sir.
Am I clear, counsel?
Yes, sir.
Have a chat with him.
Like, which one? Oh, I was wondering, would it be house arrest, like, would I be able to go to work still? That's why I was trying.
The bond conditions before were it's the same. Were you under house arrest or were you able to go to work?
I was able to go to work.
So I'm reinstating everything.
Okay.
But that's the thing, sir. You have everything to lose. You have the keys to the jail. Come with me, I'll throw them away until we get to trial if you violate. I am very serious. You understand? I'm not very nice. Don't play games. Ask anybody in the jail on your way out. Got it?
Yes, Your Honor.
Thank you. You're welcome.
Okay, thank you, Anna. 50,000, 10%. No, you don't.
Yeah. That's one time. And each time. Continue discussion.
Did Mr. Jones have another next date? I presume he did. I should have asked.
Yes, we did a pre-trial, Your Honor. We
Okay.
have a pre-trial.
Christian next.
Yep.
No, it's out.
I'm writing.
So can you call that microphone down a little bit closer? No, I mean, from the bottom, from the base down. All right, I'm sorry, what is this now?
Dean Christian.
Oh, yeah. Let's see, do I have this file? This is docket 26701 FH, 26707 FH, and 26701 FH. People of the state of Michigan versus David Christian. Counsel your appearance for the record.
That's it, insurance. We don't.
All right,
Adam Pfeiffer on behalf of the people, Your Honor.
Good morning, Your Honor. Jacob Sarge, the fourth Assistant Public Defender, appearing on behalf of Mr. Christian for both claims.
please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth and nothing but perjury?
Yes, Your Honor.
Thank you. Put your hand down. Sir, have you taken any medication yesterday or today?
No,
Are you supposed to be on medication you're not on?
no, I just say,
I don't need to know what you're taking. I just need to make sure that everything's going well.
yes, ma'am.
So you did take something?
No, ma'am.
Okay, are you supposed to take medicine that you're not on?
No, ma'am.
Any sign of fever, COVID, or other illness?
No, ma'am.
And you had no time to speak with your attorney?
Yes, ma'am.
All right, this is a final, pre-trial. And it looks like we also have a motion.
Yes, Your Honor. Today's final pre-trial conference on both files from the defense is another bond motion on these cases. These are going to be left for trial, as I do not believe that we're going to be resolving these. I made an updated offer today, that being to 5 years as a fixed minimum, down from the prior one, which was 8.
Well, there's 3 files. What is,
I
which
thought
file?
there were only 2.
I'm sorry.
I only have 2.
There's 2 files.
Oh, I'm sorry, 2 files.
701
Oh, I
and
got it.
707.
It's because there's 2 files, and one of them is also a motion, so 701 and 707. So what is the specifically offer?
The offer is, hold on. There we go. To plead guilty and file 26-707 to count 2, 3, and 5 as a habitual third offender, agree to a fixed minimum of 60 months, dismiss remainder, and file 26-701 FH. Agree not to pursue already discovered witness interference charges made prior to April 9th, 2026. The defense informed me that they've been able to speak with the victim, who doesn't want the cases to go forward and doesn't want to testify. I went upstairs and called her about 30 minutes ago. And while she doesn't want the charges to keep going, she does understand that he needs to face accountability for what he did and learn the way he did was wrong. And her exact words were, 5 years is more than reasonable for him. So the victim is on board with this offer. The defense's counter for the entirety of the pendency of these cases have been for county cap. My office will never agree to a county cap for this individual, given that he has a lengthy criminal history. He's a mandatory minimum 25-year habitual offender. And on the jail calls alone, where he tells her not to come to court, he is facing guideline ranges that go up to 114 months on each count, which can be discretionary consecutive. If found guilty at trial, which again, I do not need the victim for, given that he's the one who told her don't testify over and over, he could be facing a minimum of 45 years because of the discretionary consecutives and the mandatory minimums he is facing. 5 years is a very generous gift, and I will not be going below that. I certainly will not be doing a county cap for this individual.
So as it goes forward, the offer would be count 2, 3, 5, and habitual what?
Third,
Third.
instead of habitual fourth, so it would not be
60.
live.
Okay,
Yes.
all right. And was there a preliminary exam in this?
Yes, Your Honor, and we have the transcripts from that.
Yes.
So we could go forward if she doesn't show up, is that correct?
Did she testify at the exam? I'm trying to.
No, she did not testify at the preliminary exam.
I can still go forward without her though, because that man told her not to come to court over and over. And therefore, forfeiture by wrongdoing allows me not only to not have to worry about hearsay, but the confrontation clause.
Defense, of course, would strongly disagree, and we'll be fighting to preserve Mr. Christian's right to confront his accuser at trial, Your Honor. Thank you.
Okay. So in regard to this plea offer, your client does not want to take it, is that correct?
That's correct, Your Honor. At this time, I would request that we be allowed to continue some additional negotiations, but at this point, he's not interested in accepting the offer.
Well, there's no continued negotiations. There's going to be a trial date because I don't, this is a final pretrial. What's there to continue?
Well, Your Honor, we'll need to address the trial date. So
Okay, we'll address the trial date.
I anticipate there'll be some additional time. This latest round of negotiations, respectfully, Your Honor, have, shall we say, come together at kind of the last minute here. In terms of some of the most recent conversations that Mr. Piper and I have had, respectfully. Thank you.
So at this time, he wishes to decline the offers and it's full, fair, accurate, and complete.
That's correct, Mr. Christian. You wish to decline the offers at this time, correct?
Yes.
Was the offer full, fair, accurate, and complete?
Yes, Your
And you understood it?
Yes, Your
And you had an opportunity to speak with your attorney about it?
Yes, Your
You understand that under the agreement, the maximum is the 5 years on the minimum. And if you go to trial, the minimum could be 45 years or more.
I think so, Your Honor.
What do you mean you think so? Do you need more time to talk with your attorney? There's a big difference between 5 years and 45 years. And I don't know anything about your case. So I don't know what did or did not happen. It's up to you, but you're taking, that's the chance you're taking. 5 years versus 45 years. So I don't know what happened, and if none of this happened, go to trial by all means, but I just want you to make an informed decision. And you look like you have a question mark on your face. Do you need a few more minutes with your attorney?
Yes, Your Honor.
Okay, counsel, let me know when you're ready.
Thank you.
Thanks, man.
We will handle, Joshua Snell, Your Honor.
This is docket 26-181 FH, people of the state of Michigan versus Joshua Snell. Counsel, your appearance for the record.
Good morning, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan.
Thank you, Your Honor, and good morning. Jared Austin, appearing on behalf of Mr. Snell. He stands present to my right.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
You put your hand down. You're taking any medication yesterday or today?
Yes, Your Honor.
Is it anything that would interfere in your ability to understand your attorney or the court?
No, Your Honor.
And is it medication you're supposed to be on that you're not on?
No, Your Honor.
Any sign of fever, COVID, or other illness?
No, Your Honor.
And this is a final pretrial. Has there been an offer on behalf of the people?
Yes, Your Honor, and there is a plea. I just handed that plea sheet to your staff.
Okay, we'll just wait a moment. I'll sign that.
Writing it out really quick because someone signed where you're supposed to sign.
Okay. All right, court is in receipt of the agreement as well as a fee waiver request for the signing and the advice rights. And we'll get you copies in just a moment. All right, sir, are you a US citizen?
Yes, Your Honor.
What you're pleading to, were you on probation, parole, or bond conditions before another judge?
No, Your Honor.
You've had enough time to speak with your attorney about everything?
Yes, Your Honor.
All right, and are you employed?
Yes, Your
What do you do?
Honor. I'm a cook at Ellison Brewery, and I'm starting at LG Solutions next week sometime.
Okay. You have a nice deep voice, so we got the microphone there. I know you feel a little tall for the microphone, but you don't have to keep bending over, you're gonna get a neck ache. All right, so, did you graduate high school?
Yes, Your Honor.
And I have you living on Cedar Street, is that still correct?
Yes, Your Honor.
And who do you live with?
Just myself.
Okay. What is the plea agreement on behalf of the people?
Yes, Your Honor. The defendant will be pleading no contest to count 2, child abuse in the 3rd degree. Upon successful plea and sentencing, count 1, assault with intent to do great bodily harm, less than murder or by strangulation shall be dismissed. There is an agreement to no upfront jail at the time of sentencing. Any restitution will be held in reserve for the sentencing. And I believe that's it, but if I could just wait one moment for a copy of the plea form back, I can confirm.
All right. And was the mother and victim?
Yes, Your Honor, the people had a chance to talk to, the mother on the phone this weekend, or yesterday.
Looks like you've outlined.
And that is, yes, that is the extent of the plea
All
agreement.
right, thank you. Is that full, fair, accurate, and complete, counsel?
That is my understanding of the plea offer, Your Honor. That's what I've conveyed to Mr. Snell. It's been reduced in writing and reviewed and signed by all parties on the plea agreement form.
Sir, is that full, fair, accurate, and complete?
Yes, Your Honor.
And was this your child?
Yes, Your
Okay, and are you paying child support on this child?
Honor. As of now, yes.
Are you seeing this child?
I have no contact with her right
Very good, okay. Counsel, are you waiving reading count one
We will so waive.
as to count two?
Yes, Your Honor. People of the state of Michigan versus Joshua Javon Snell, State of Michigan, County of Ingham. In the name of the people of the state of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on the date and the location described below, the defendant in count two, child abuse third degree, on or about December 22nd, 2025, at 411 North Cedar Street, Unit 202, Lansing, Michigan, 48912, Ingham County, State of Michigan, the defendant did knowingly or intentionally cause physical harm to a child, contrary to statute. This is a felony that is punishable up to a maximum of 2 years or probation for up to 5 years. Court shall order law enforcement to collect DNA identification profile sample before sentencing or disposition, if not taken at the time of arrest and against the peace and dignity of the state of Michigan.
Sir, did you understand what was just read?
now. Yes, Your Honor.
So you understand count two, child abuse third degree is a felony punishable by 2 years or probation for up to 5 years.
Yes, Your Honor.
And it looks like you signed the advice of rights form. Did you read it before you signed it?
Yes, Your Honor.
Did you understand what you read?
Yes, Your Honor.
And if you had any questions about your rights or anything else, you were able to ask those of your attorney?
Yes, Your Honor.
And do you have any questions about your rights at this court?
No, Your Honor.
And you are going to be pleading no contest based on civil liability, is that correct?
Correct, Your Honor.
And sir, are you pleading of your own free will?
Yes, Your Honor.
Did anyone force, threaten, coerce, or promise you anything other than the plea agreement?
No, Your Honor.
You made this decision after you talked to your attorney,
Yes, Your Honor.
and you've been satisfied with the representation of your attorney?
Yes, Your Honor.
Sir, as to child abuse third degree count two, how do you plead?
No contest.
And you understand there's no contest plea enters as a guilty plea, although you've not pled guilty.
Yes, Your Honor.
Okay, and so you would have to submit to the orders of the court.
Yes, Your Honor.
And you understand that by pleading, you're giving up certain rights and defenses you would have had you had a bench trial, jury trial, such as the presumption of innocence, the ability to cross-examine witnesses, and evidence, the ability to provide a defense, to hold the people to their burden, et cetera. You understand all that, you're giving that up.
Yes, Your Honor.
All right, very good. And has anyone told you, other than the plea agreement, what I will do at sentencing?
No, Your Honor.
And do you understand that if I don't follow the agreement, there's an agreement for no upfront jail, if I gave you upfront jail, then I would allow you to withdraw your plea in this manner, would again go to the pretrial stage?
Yes, Your Honor.
Do you understand that if you violate the law or bond conditions, I don't have to follow the agreement, and I don't have to let you withdraw your plea, do you understand that?
Yes, Your Honor.
Sir, did this offense occur on or about December 22nd, 2025?
Yes, Your Honor.
In the city of, oh, I'm sorry, there's a no contest, so let me have the, I have any of the police report.
Defense has a copy, Your Honor.
Thank you. Okay. So it does look like Lansing Police Department reported on that date of December 22nd, 2025. It's incident report 257528. At approximately 1958 hours, officers were dispatched to 411 North Cedar Street for a report of a stabbing. And the caller advised that she received a call from her daughter, who said that her father was choking her. And she cut her father in self-defense. Officers were dispatched to 601 North Cedar Street, apartment 411. Made contact with the residents. And then went to the new address of 411 North Cedar Street, apartment 202. They stated that the minor child was nearby at her apartment, 525 North Cedar Street. And the officer was advised after interviewing the child that she was the victim of strangulation, which occurred in her bedroom at 411 North Cedar Street. When officers arrived, they made contact with the female at the door, who stated she was the mother of Joshua, who was inside the bedroom. No injuries were noted. The child gave the following statement. She was sitting on the couch watching TV when her father, defendant, arrived home. He yelled at her to go to her room and then went into her room and asked her to wash the dishes. She said that she may have taken too long to wash the dishes, so he came back into her room and told her that he was going to destroy her belongings if she didn't do the dishes. He then called her mother. After he was finished on the phone with the mother, he came back into the child's room, and she was already cleaning something in her room, and he told her to stop and go wash the dishes. She finished what she was doing, and he got angry and pushed her. And there was a short pushing match between the two where they both pushed each other. After the pushing match was over, the defendant began strangling the child, and he was standing in front of her and wrapped both hands around her neck. She could not breathe, and she saw stars while she was being strangled, and she, however, never lost consciousness. She fell to the ground, crawled under the bed, and grabbed a steak knife with a black handle. It was determined that it was used in self-defense. She had a cut between her left index finger and left thumb, approximately 1 inch in length. It was not bleeding while photos were being taken. While photos were being taken. She also had a small open wound midway up the left side of her neck. The wound was slightly bigger than the head of a pin. There was discoloration on both sides of her neck, and she was advised that she advised officers that she was strangled, and that it went on for less than a minute because she could not breathe during the strangulation and saw stars but did not lose consciousness. I think that is proper factual basis. Counsel, you may retrieve your police report unless either one of you wants something else for adding to the record.
People are satisfied, Your Honor.
I'm satisfied, Your Honor, thank you.
All right, thank you. Our counsel, where promises, threats, or inducements other than those already placed on the record,
No, Your Honor.
I'm aware of none.
and this court complied with the court ruling.
You have, Your Honor.
Court has, Your Honor.
Thank you. I find Defendant's no contest plea given civil liability and circumstances of this case to be appropriate. I also find no contest plea has been freely, voluntarily, knowingly, and understandingly made without undue influence, threats, coercion, or promises of leniency. I also find there are sufficient grounds based on the police report, which has a couple of different interviews and descriptions of the same circumstance. So I find there are sufficient grounds and the elements have been met in count 2. Therefore, count 2 will enter. Count 1 is hereby dismissed along with any outstanding warrants, if any, related to this file. Do we have a sentencing date?
October 21st at 9:30 a.m.
Does that meet with your schedule, counsel?
It does, Your Honor.
Sir, today you should go downstairs on your way out and maybe keep an appointment with probation. They'll do a detailed pre-sentence investigation report that we'll talk about at sentencing. If you don't have time today to do that, then within 24 hours, you need to call probation. The numbers on the purple sheet that we're going to give you, 517-483-6100, is just a whole lot easier if you go downstairs and counsel can direct you. Bond conditions are continued. That would include a no contact order with, how old is this child?
She just turned 16 years.
Okay, so no contact means no Hallmark cards, birthday cards, phone calls, messages to third parties. You don't go to her school, you'll not be within her, where she's living. She's living with the mom?
Yes.
Okay, and no continue to pay child support. And no visitation. So is there, were you married to the mother?
No.
Okay. But there are court orders that order you to pay child support.
Yes.
And do those orders also include visitation? Okay, well, by the order of this court, there is no visitation. Understand?
Yes.
Okay. Anything further?
No, Your Honor, thank you.
Nothing further on behalf of Mr. Snell at this time, Your Honor. Thank you.
Thank you. That's all for the record.
I'm gonna recall Christian.
We are back on the record on docket 26707 FH and 26701 FH, People of the State of Michigan versus David Christian. Counsel, have you taken the extra time to talk with your client about whatever you wish to discuss?
Thank you, Your Honor. Yes, and I appreciate the extra time. Thank you, Your Honor.
And no problem.
Thank you.
And so are we still going to trial or will it be a plea or is there something else you'd like to discuss or make a record of?
Thank you, Your Honor. At this point, Mr. Christian still requests that we proceed on to trial. However, I would request that the usual parameters in terms of plea negotiations be left just a little bit longer open, because I anticipate we will have to address the trial date here in a moment, and it's potentially going to be later than the currently scheduled date, Your Honor.
What is the new trial date? Do we have one?
We don't have one yet, Your Honor. We're
Oh,
currently
we
separate.
will before we leave today.
Mr. Buxton informed me that we're looking at potentially October 3rd.
October 30th?
Yes.
Does that meet with your schedule, counsel?
That's a good question, Your Honor.
And my issue is October 30th, is that realistic, given that this is a 26 case? I know he's in custody, but we have.
It's the only in custody on that date.
Is it? Okay.
And I'm the one before it, so I can figure
Work
it
it
out.
out. Okay,
I can work it out myself.
okay.
I might have some scheduling issues, Your Honor. I'll have to check my trial docket for October. But I'm fine leaving that on as the current date for now. But I'm booked pretty solid all the way through till basically February at this stage.
So am I.
Yeah. Well, yes, especially in January. But my apologies, it's gonna take a moment before I can get my computer up and
That's
running
okay.
here.
So what was the motion in limine? Are we addressing that today?
Yes, please, Your Honor. Simple motion, defendant's motion eliminated prohibit the use of the term victim in the trial itself, Your Honor. This is a fairly standard motion. We routinely file these in these types of cases. In defense counsel's experience, it's a common practice, the complaining witness be referred to as a victim. And when the case is being presented to the jury, the use of the term victim, Your Honor, presupposes that a crime has occurred, and according to the definitions in Black's Law Dictionary, specifically the term victim, Your Honor, would violate Mr. Christian's right to a fair and impartial jury, respectfully. And Your Honor has heard this particular motion brought from our office numerous times. The crux is still the same. And for the reasons we state in our brief in support, that term is very prejudicial. It is presupposing that a person has already been convicted, or it's presupposing, Your Honor, and implying a complaining witness has already had something done to them without a chance for the jury to hear all of the evidence and make their own conclusions regarding whether, in fact, the incident occurred. So it is something that's just highly prejudicial, Your Honor. It doesn't, that particular term doesn't add that much to the probative value of the case itself. However, the implications of that term, Your Honor, certainly are very well known, and so is the meaning. So because it's a loaded term, Your Honor, and because it's very prejudicial, without really adding any sort of probative value to the presentations of the case itself, respectfully, we would ask for a limiting order as to its use in the trial itself. Thank you.
And I'll give the people a moment to respond, but I'm going to respond first. I believe my common response, which has been upheld, is that the word victim will have before it alleged victim, and that takes care of any taint. We have the people, would you like to weigh in? And does anybody have any case law? I think that I've been upheld on using alleged victim.
There is case law. I missed this motion. I only saw that there was a bond motion, in all honesty. However, I've dealt with this argument before. The defense is wrong. The case law is very blunt that the people are allowed to refer to them as victim. And what the defense actually said there of everyone knows something is actually the exact reasoning the appeals court had when they ruled on this in the favor of the people, because it is not providing any new information. It is not tainting anything or implying anything. The actual ruling of the appeals court is the jury knows the people believe she's a victim. There wouldn't be a trial without that belief. It would be a violation of the people's ethical duties to have someone up there that we did not believe is a victim. It does not bias the jury. It does not taint the jury. So the only case law, and it's from February, if I remember correctly, sides squarely with the people. No alleged. They're allowed to say victim. It is different for a witness or law enforcement to say, no, that is a victim, that is a victim. It is not for the people. And the last time that I was in front of you, your ruling was the people were allowed to refer to her as a victim in opening and closing, if I remember correctly, just not in regards to questioning with the officers. And again, that's fair.
And that's because that comports with the jury instructions. That's how you see the case. But
Exactly.
During, in between opening and closing, it will be alleged victim.
Exactly.
There's the ruling. Same as before, we can continue to make a record, and maybe the Court of Appeals one day will make a further record themselves.
And I will say, if I slip up, I will work to correct myself when it happens. I try and refer to them by their name when questioning law enforcement and things along those lines.
Thank you, Your Honor.
Would you like to prepare an order as to that?
Yeah, sure, Your Honor.
Great.
I believe we can produce one quite quickly. May I be just heard again on the trial date, Your Honor?
Yes,
Thank you. Yeah, I'm currently scheduled for a trial before Your Honor on October 23rd and also October 9th. The one that I have on October 23rd, Your Honor, is Christopher Riggle. And the one that we're scheduled before Your Honor on October 9th is Mr. Garza. Because I already have two other trials and because it's possible with a case like Riggle, which involves multiple files, Your Honor, a bunch of potential witnesses and involves Mr. Pfeiffer, that trial might also potentially run into the 30th. It could go over a week. So respectfully, Your Honor, rather than getting into a situation where I have to run back-to-back trials and back-to-back weeks, I would just respectfully request a different date other than October 30th. And that's due to having what would amount to basically 3 trials in the month of October, all before Your Honor, if it's set to the 30th. Thank you.
I don't know that all 3 will go, but I think what I'm gonna do is leave them on, however, move the October 30th to also another date. I think my prosecutor can move it to a backup on a civil docket.
30th is a backup in the civil docket, so is 23rd.
Oh, well, how
Yeah.
about my next civil
And-
docket in November?
That would be unfortunately, unfortunately, the civil
Thanksgiving.
docket is Thanksgiving,
Well, how about the
so it would be
weekend?
December 4th.
Great, so if it's not October 30th, it'll be December 4th. Let's see how it all plays out, because I'd like to say that the 9th, 23rd, and 30th will all go, but the odds of them all going back to back, I don't know how high they are, the way the cards shuffle around here, so
It's me again on that day, so I'll know when we get closer.
so you all work it out, let's just keep working toward resolution. I don't wanna put it out into 2027.
I will say, people aren't going lower than what we've done.
The people are what?
The people aren't going lower than what we've offered here today. That's it.
All right. So, trial.
Thank you, Your Honor. And may I be heard on the bond motion, Your Honor?
Sure.
Thank you, Your Honor. Respectfully, on behalf of Mr. Christian, defense counsel requests a reduction in Mr. Christian's current cash assurity amounts on both files. In terms of the bond report, Your Honor, I would note that this is essentially the same report that pretrial services had submitted previously. We have since corrected the felony information. The charges, the domestic violence third charges have been correctly reduced down to domestic violence first offenses. That's not going to be reflected in the bond report, Your Honor, but Mr. Pfeiffer's office did file the correct amended information just recently, and that clears up that issue in terms of Mr. Christian's charges. So rather than the felony counts of domestic violence thirds.
May I approach? Thank you.
Thank you.
Those counts have been reduced down to domestic violence first offenses. The second issue, Your Honor, the people allege that Mr. Christian absconded or had warrants for failing to appear on a couple dates, Your Honor. That's also reflected in the bond report, specifically failures to appear on cases from February 20th, 2002, March 16th, 2002, and March 18th, 2021. Respectfully, Your Honor, having had the opportunity to review these allegations with Mr. Christian, to the best of his memory, and he's trying to rely on his memory here, to the best of his recollections back in that period of time in 2002, so February 20th, 2002, March 16th, 2002, he was in prison. He was at the SAI boot camp, to the best of his recollection. So he would respectfully disagree with allegations that he missed a court date. It's possible, Your Honor, that it just could have been a situation, and this does happen, where a district court is not aware that a person's in a prison program, and they will issue a warrant even though They don't know the person's location, or, and having practiced in Grand Rapids, I had situations where they'd issue a warrant because they just simply didn't want to spend the money on ridding a person over from a boot camp or from an MBOC program. As for the allegation of March 18th, 2021, Your Honor, Mr. Christian at that time recalls being represented by Josh Kuiper out of Grand Rapids. While that case at the time was proceeding, to the best of his recollections, Your Honor, he didn't miss any court dates on March 18th, 2021. And he did have counsel at the time, Mr. Kuiper. I'm not sure how much further we need to go into that, but I would just like to make a very clear record, Your Honor, that Mr. Christian denies any allegations that he missed previous court dates, Your Honor, or that he failed to appear, or at least for court dates that he was aware of, Your Honor. Okay, so as to the bond motion itself, Your Honor, I submitted a bunch of certificates and a bunch of other paperwork from the jail. Your Honor, Mr. Christian was very, very active during his time in the county. He has participated in 12-step programs. A bunch of services with Pastor Chris. He's learned about drug and alcohol abuse. He has certificates from successfully completing anger management, adapting to change, a student guide to drug and alcohol abuse. He's a bunch of certificates from that. He's been working very closely with CATS, Your Honor, and CMH on trying to get treatment, Your Honor. He's worked extensively with Daniel Waits, and we have a letter from him that was also included. Mr. Waits works for CATS. He's worked extensively with Miss Beverly. If he's released, Your Honor, what Mr. Christian wants to do is go to treatment. In addition to going to treatment, if he's released, he would potentially have a job still. He has good employability, Your Honor. He can go out, he can get a job. He was working for a dealership, but before he got picked up on this, he had a good stable paycheck, Your Honor. He's also broadened his career horizons by completing, the Case Credit Union's financial wellness course. He also completed Seeking Safety, Your Honor. And above all else, though, he really wants to get into preferably inpatient or outpatient, Your Honor. He brought a bunch of pamphlets with him today for Cedar Roots. That would be his goal if he was released, Your Honor. Further, he would have a stable place to stay. He has certainly friends and family in the community and in the greater Mid-Michigan area. He has a brother that he's very close with out in Grand Rapids. He would have plenty of opportunities to find stable housing if he was released, Your Honor. The use of GPS tether monitoring and a tether device will be sufficient to make sure that there's no contact with the complaining witness. Your Honor, the complaining witness has good communication with Mr. Pfeiffer, so if there are any issues, she could certainly reach out to him. That's not going to be an issue. So respectfully, Your Honor, at this point, having observed Mr. Christian serve over 8 months at this point, given his successful efforts to prove to Your Honor that he can stay out of trouble while he's in jail, given all these efforts to participate in all these classes, and respectfully, Your Honor, at this point, Mr. Christian has proven to Your Honor that he is worthy of a bond reduction here and that he will comply with all Your Honor's orders in the future if he is given an opportunity to be released. That being said, of course, Your Honor, the charges here are very serious, and we do have a trial date that's set at this time, but even a few months at this point, Your Honor, would be immensely helpful for Mr. Christian to be able to get out and reestablish bonds with his family. His family has been through a lot since Mr. Christian has been in custody. His nephew was in a tragic motorcycle accident, broke a bunch of bones in his body. He's lost 2 aunts. He wasn't able to go to either of those funerals as he's been serving his time in jail. And Mr. Pfeiffer is going to have a lot of sharp comments. He will do his usual objections, Your Honor, but still, at the end of the day, Mr. Christian at this point has been in jail since January, and he's learned a tremendous amount going through this process. He's been very active, and especially as it relates to seeking treatment And all at this point he's asking for, Your Honor, is an opportunity, a chance. And with all the options that Your Honor would have at Your Honor's disposal of Mr. Christian, so much as went out of line a little bit. He understands the consequences would be very harsh and very severe. So respectfully, with that in mind, Your Honor, I request a reduction down to preferably personal recognizance bond on both files. Thank you.
Let me ask people,
How detailed does the court want my response to be here?
make your record.
He knows the consequences because he's been in jail since January on contempt of court. Over and over. He's warned every time and then he kept doing it over and over. He did not get done with his contempt of court from you until July 11th. It's by his own acts, irrespective of the underlying charges here, that he's been in jail for so long. He has not proven that he's worthy of this because it seems like he's lying to his attorney today. He was not in prison. There's no record of him being in prison at the time of the failures to appear in 2002. I know I looked on the Otis site. He was put in prison in 2003 after he had bench warrants issued against him for other assaultive cases. That's just not, there's nothing to show it's true, and all the evidence shows the opposite. But that's also very in keeping with this defendant who has denied making calls to the victim at the district court level, at this level, and we have had to have numerous contempt of court hearings with witnesses on the witness stand, because even with the recordings and the logs, he still refuses to acknowledge that he has violated the orders of the court, even after the court, multiple courts now have found him guilty of doing so. He is a mandatory minimum 25-year habitual offender. These are two different felony assault files, both of which now have witness interference on them. His guidelines are incredibly high. On the jail calls alone, which there is no defense for, because he says point blank, don't come to court, don't ever come to court. His guidelines are between 29 and 114 months each. And there is no defense for those. This is not someone who is deserving of a PR bond by any means. And I don't believe he's deserving of a reduced bond. It's great that he's now going through programs after his second contempt of court that he was found in. I'm glad that he's been making use of that time, that he's been forced to be in jail. I do think it's comical that one of the certificates that was included was from December of 2025 when he was still actively contacting the victim from jail. So I don't know what to say here, Your Honor. I do not believe that this individual is a good candidate here because of his storied history in the district court and the circuit court of violating the orders of the court, of his criminal history, not only of his convicted crimes, but also of his failing to appear. I think bond is appropriate where it is. I think that he should remain on this bond pending his trial date.
Sir, anything you want me to know?
Well, just to clarify, Your Honor, to the best of Mr. Christian's knowledge, in 2002, he was at SAI boot camp, which would not necessarily be reflected in notice as related to those February 20th and March dates. My apologies, Mr. Christian, go ahead.
To that point, that does mean there's more crimes that are missing from his criminal history then.
I know that I made bad decisions in my past. These are 20-year-old cases that I took responsibility. I went to prison for it, and I learned. I ain't been in prison since 2016. That's over 10 years ago. I learned my lesson. I know what I've done in my past as well. I will admit to all my wrongs, but now I'm here trying to get a second chance of my life to prove that I am a good man. I know that I deserve a second chance because I've been in trouble in so long. And now the allegations that I have, if I get found guilty, then I'm guilty. I can't change that. But here as today, I'm not guilty on these charges.
That's correct, sir, but we're looking at public safety, and you have since 2002 a continued escalation. You had a number of things that half of Michigan has operating while with license suspended. I'm not even considering any of those. But you had a number of times you were in front of the court where they were dismissed, okay? Even not looking at that. Since 2002, you have had a consistent escalation. You've had some really long times where you've done really well, but then you end up being in front of a court. And you did go to prison on some drug charges in 2011. And then you also, let's see, 2011, 2014 prison. And then you had 2020. Most of the counts were non-crossed, they were dismissed, but you were sentenced to 2 days jail and 3 years probation on assault with a dangerous weapon. Then we have this escalation now to the current charges, which interfering with electronic communications, 2 years. It's punishable by 2 years. Domestic violence, a 93-day. Witness bribing, intimidating, a 10-year. And then you have the habitual fourth with the minimum of the habitual 25-year minimum. And then on the other docket, you have unlawful imprisonment, a 15-year. Assault with intent to do great bodily harm less than murder, a 10-year. Witness bribing, a 10-year, and another count of domestic violence, 93-day. But there's that habitual fourth with a mandatory 25. And your guidelines are horrible. I don't even know if you can go to residential treatment. I agree you need residential treatment, sir.
Please.
But without, what we see is that I can put people in treatment once there's a plea. With all this pending, no one's gonna take you. Okay, get you into treatment. And you're innocent until proven guilty beyond a reasonable doubt.
I would love to take a plea, Your Honor, and to go to treatment. I do need the help, and I don't want to return to society without it. I wanna get help. I wanna change. And that's one thing that I never had in my life was residential treatment. I always had prison. And, you know, I really need that help.
You absolutely need residential treatment. However, what you want is the people have negotiated a 25-year mandatory down to a 5-year, which is a fifth. Am I right? A fifth of,
No, it's less than a fifth because you're only counting one of his 2 cases.
well, okay. So 2.5. And I'm not good at math. 2.5% of what you could get. They're not coming down. You want a year misdemeanor.
I can do whatever, if I can get a good plea to go to treatment right now, take plea to something right now, I will do that, Your Honor, with no problem. I will do that, just to go to treatment, because I need it, and I want
You
it.
need it, but their offer is for 5 years prison. So
Is there any treatment in there? Can I get any possibility of treatment, residential?
even if you do residential treatment, if I have you in jail, go to treatment, you'll go back to jail, and then you go to prison under this plea agreement. So that's how it would work.
Say what, pardon?
If you do a plea, I would consider sending you from jail upon acceptance to treatment, to residential treatment, to be returned to jail, to be sent to prison for the rest of the time.
Essentially, she's informing you that she would be open to what amounts to like a delayed sentencing, sir. So Judge Aquilina would be agreeable that if you were interested in a plea deal that would require.
I'll take it, it don't matter, I'll take it.
You want to talk to him further?
Yeah, please, Your Honor. If
Okay,
we could-
and I want to add, because I want you to have a little sidebar with him. Sir, if you went to treatment and you absconded, the deal would be off, and I'd be.
I will never stop, I will take it, I understand.
Sir, but I just want you to understand, because then we end up with all these appeals that sit in the Court of Appeals for 3 years. So I want you to be very clear, because I want this issue off the table.
Yes, ma'am.
If you abscond from treatment, the deal is off. And then
Okay.
I will send you to the 25 years.
I totally understand. I'll
Okay.
take that.
Counsel, you go talk to him, let's be very clear, and then we'll do the plea, if that's the way he wants to go. Do the people agree?
Yes, Your Honor.
Great.
Okay, thank you, Your Honor.
Okay, that's what I thought.
Right? Yeah. Mr. Pfeiffer, did you want to start writing that up? Or, no, you got it? Okay, very good. See your head. Good deal.
We could handle, Daniel, Oliver, which is the set aside,
Okay, great.
or Daniel Neely, I believe he's on the docket.
This is docket.
Okay, sorry.
This is docket 13-622 FC, People of the State of Michigan versus Daniel Oliver Neely. Is it now, did he change his name or?
Sorry, yes, Your Honor. He's adopted and he chose to change his name.
So now is it Daniel Oliver formerly Neely?
It's without, he dropped the, and you can, or he's dropped the Neely. Is that true, Daniel?
Yes.
So it's Daniel Oliver?
It's Olivier.
Olivier, so it's Daniel Olivier.
Yes, that's correct, Your Honor.
Okay. So. All right. I'm wondering if I should change the caption to formerly known as, or AKA, just so they get the underlying documents correct.
Sure.
Rather than just putting it in parentheses, because it sort of looks like maybe it should be hyphenated or it's, I don't know. Let me just change the caption a little bit, just because we need it to be done correctly in terms of how they find it.
Okay.
All right, thank you. Counsel, your appearances for the record.
Good morning, Your Honor. EPA Bart Buxton on behalf of the people of the state of Michigan.
Thank you, Your Honor. Rebecca Nybert serving on behalf of Legal Services of South Central Michigan and Daniel Olivier. Daniel, can you state your name for the record, please?
Yes, it is Daniel Len Olivier.
And please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes.
Thank you. You may put your hand down. looks like the application is set aside, the conviction was filed on June 25th, 2026 or 2025. I can't read the printing on this. Looks like maybe the 26th, is that correct?
I have June 19th, Your Honor, 2026.
Well, we received it on the
Okay.
June 23rd, so I'm just gonna, you may have, did you send it in rather than?
Yes, I did. I put it in there.
Okay, so I'm just gonna put June, because technically that's when it was filed. June 23rd, 2026. All right, and the date of conviction was September 18th, 2014. Counsel, on behalf of the people, are you in receipt of the required documents from the state police and the attorney general, and do the people have any objection?
Yes, Your Honor, the people have received the MSP as well as the letter from the Attorney General. That letter from the Attorney General states that Mr. Olivia may be eligible to have his conviction set aside as long as his post-conviction circumstances and behavior warrant the setting aside. The only thing I want to note, Your Honor, is this was a case that was a criminal sexual conduct in the first degree that was brought down to seduction. And in my notes, in this case, the prosecutor talked to the victim back in 2014 at the time of the plea, and very specifically gave this plea to seduction because at the time, expungement would not have been available to him because he had a prior DV conviction. So that was the reason that the plea was to a seduction. It was for this expunsion to not take place. So that is why the people would be in objection, Your Honor, but ultimately I'll leave it in the court's discretion.
All right, thank you. Was the victim contacted?
Our office did send a letter to the victim, Your Honor.
And is the victim here?
I don't believe she is, Your Honor.
Thank you.
1 second, is Jacqueline Ross here? She is not, Your Honor.
Thank you. On behalf of your client, counsel.
Thank you, Your Honor. I have quite a bit to say about him, as I think it's important. Daniel is a family man first and foremost, and he has always put his two boys first in his life. He's worked incredibly hard to obtain full custody of his sons to ensure that they are receiving the best care and support possible. The boys previously lived in Wisconsin, but since moving in with Daniel after he was first granted custody, the turnaround has been amazing. They have gone from receiving Fs, failing, to excelling.
So you need to slow down.
Oh, okay, sorry.
And you need to start from, he has gone from receiving.
Oh, thank you. He's gone from receiving, the boys have gone from receiving Fs, failing, to excelling in school with all A's and B's. They have the time spent with sports, and you better believe that Daniel is out there cheering them on the whole way. Despite having full custody, Daniel strives to co-parent with his ex. He consistently puts his children first and does everything he can to maintain a good relationship with their mother. He wants the boys to learn by example and believes that treating people the right way starts with treating their mother with respect. Daniel's dedication to family comes from his own upbringing. He was adopted by his godparents who stuck by him through the rough patches and showed up for him no matter what. His godmother was a sheriff's deputy, so she certainly did not let him get away with much around the house. They saw the potential in him and made sure he saw it in himself. Eventually, Daniel realized he wanted to do better by watching his siblings live good lives. And with 36 siblings to live from and learn from, he had plenty of examples, Your Honor. Daniel has also shown incredible dedication to his career. He worked at Wendy's for 10 years and now has spent approximately 10 years working as a plant manager at his current shop. In his current role, he has the privilege of working with felons, giving them a chance to prove to their boss and coworkers that they are back on track and turning their lives around and becoming great men. Daniel likes spending his free time with his boys camping and fishing and doing just what the boys want to do. Daniel is seeking this expungement to finally feel free of the stigma of being labeled as a criminal. It would also help him to participate in field trips with his children, including an upcoming White House trip. It is also would help with this future employment opportunities if he ever needs to shift positions or careers, as he has been denied employment in the past due to his record. He wants to sincerely thank this court for having this opportunity, Your Honor.
Thank you. Sir, what would you like me to know?
Yes, Your Honor. I would like to say, I had turned my whole life around since, being convicted, and I feel like, I had did my time and proved that I am a better person for, the community, and I do everything in my power to, show that.
Well, it certainly seems like you have made amends and have become the citizen that you should have been all along. So, sir, I am going to grant this. An application to set aside the following conviction was filed on the 23rd of June, 2026, deduction in docket 13622 FC. The court finds the Michigan State Police has reported the required information, as has the Attorney General. The applicant has not been convicted of more than 3 felonies. The applicant has had no convictions for an assaultive crime set aside pursuant to the statute during their lifetime. There are no criminal charges pending against the applicant, and the applicant has not been convicted of any criminal offense during the applicable time period. The applicant has not previously had a felony conviction for the same offense set aside pursuant to the statute, and the applicant has not previously applied to have and had a first violation. I don't know why that is checked. That does not apply. Check that. Move on. Okay. The time period required by the statute for the conviction listed in item 1 has passed, and an opportunity has been given to the Attorney General, prosecuting official, and state police to contest the application, as well as there has been the victim notification, and the victim is not here additionally to further contest the application. Therefore, circumstances and behavior of the applicant from the date of the applicant's convictions to the filing of the application more than warrant and justify setting aside the conviction, and it is consistent with justice and public welfare. And the application is granted as to the conviction listed in item 1. And pursuant to the statute, the Michigan State Police shall maintain a non-public record of the order setting aside conviction and of the arrest, fingerprints, conviction, and sentence of the applicant in the case to which this order applies. If the court or arresting agency maintains a record of the arrest, biometric data, conviction, or sentence, that record shall be non-public and not used for any purpose unless authorized by law. Sir, if you were here, I would ask you to approach and hand you your order. The court has read it, signed it, dated it in open court. It is ready to be presented to the clerk. My clerk is very good, and she will get this entered today. If you find in the next 3 or 4 weeks this has not been entered by the other agencies, let me know, and I will make a phone call on your behalf. The last order of this court is to go out with your family and have a celebration. This certainly is a momentous occasion, and I'm just handing you this and shaking your hand virtually because that's the only option. So congratulations and good luck to you, sir.
Thank you, Your Honor. I have one question.
Yes.
am I allowed to, because I just live in Jackson, I have an assistant here that can run a shop. Can I just drive to Lansing and come and sign it?
And can we get it? Sure, you don't
Yes.
wanna wait for it to be mailed, you can pick
No.
it up, we'll have a copy waiting for you, just come up to the third floor and we'll hand you your copy, okay?
Yes, thank you, Your Honor.
All right,
Thank
the
you.
council will mail you yours, all right? Or is that all right, or you want it emailed? Either way.
Either way is fine, Your Honor.
All right, it's here waiting for you, sir.
Okay, thank you
Congratulations.
so much.
All right.
Thank you. Thank you.
We're ready to go back on the record.
Okay,
I guess just let me go.
do we have the documents?
Not,
What?
not gonna be needed.
Oh, all right.
Hold on.
We are back on the record on the Christian Matter Council.
Thank you, Your Honor. Certainly, Your Honor's idea is a very good one. However, the stumbling block we're having right now is Mr. Pfeiffer's insistence on the 5 years, Your Honor. Mr. Christian absolutely wants to get treatment. He's open to treatment, but right now, at this point, that would be the stumbling block to him accepting the deal. At this point, he's just not willing to accept an offer that would require him to serve a minimum of 5 years in prison. He's had some time to think about it, Your Honor, but his goal is still the same, and I'm still making the same request as it relates to this bond motion this morning to allow Mr. Christian to have that opportunity. Certainly something that he wants to pursue, and with everything that's going on with the trial docket and given the relative new date of this file being a 2026 file, even for that matter, if Your Honor wanted to push the trial date back into 2027 to allow Mr. Christian to have the 90 days or 120 days with very sharp restrictions on bond if he ever absconded from it. That's another potential solution here too as well, Your Honor. And further, it might alleviate some of the concerns that at least I have about docket congestion for the remainder of 2026, Your Honor. Thank you.
He doesn't want treatment, he just doesn't want to go to prison.
Yeah, sir, I'm not changing anything. We will set this for trial.
Thank you, Your Honor.
Thank you. That's all for the record.
So as for bond, Your Honor, is the court,
Nice, no change.
no change.
Good night.
Thank you, Your Honor.
We're gonna handle Bolton Brown next.
This is docket 24-635 FC, People of the State of Michigan versus Golden Allen Brown. Counsel, your appearance for the record.
Morning, Your Honor. Randall Berman on behalf of the people. Good morning, Your Honor. Assistant Public Defender Stephen Feigels on behalf of Golden Brown, standing to my right today.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth on the penalty of perjury?
I do, Your Honor.
Thank you. Put your hand down. Have you taken any medication yesterday or today?
Yes, ma'am.
Is there anything that would interfere in your ability to understand the court or your attorney?
No, ma'am.
Is there medication you're supposed to be on that you're not on?
No, ma'am.
Any sign of fever, COVID, or other illness?
No, ma'am.
And you've had no time to speak with your attorney?
I have.
All right, counsel, what are we doing in this file today?
Your Honor, today's the date and time set for final pretrial. I have made a offer. It's been fairly consistent, a little bit of change throughout. I have extended that to Mr. Feigelson. It's my understanding the client wishes to reject that, proceed to trial. When the court is ready, I will state the agreement for the record.
Court is ready. What is the agreement?
Thank you, Your Honor. The agreement was for the defendant to plead guilty to count 2, home invasion first degree, as an habitual offender fourth. The people would then dismiss the balance of the file, that being count 1, carjacking, count 4, 5, 4 and 5 being fleeing and elude a police officer, 6, 7 driving reckless, and then an added count 8 was added of police officer fleeing and eluding again. And then we would also dismiss the habitual offender fourth mandatory 25-year notice, because he'd be pleading to a regular habitual fourth, just to avoid the confusion there. The agreement also called for the defendant to serve a fixed Michigan Department of Corrections sentence of 15 years. And he's currently, if convicted, facing minimum of 25. It's my understanding that that's being rejected and we will proceed to trial.
Okay. Is it full, fair, accurate, and complete?
Yes, it is, Your Honor.
Full, fair, accurate, and complete?
Yes, ma'am.
And did anyone force, threaten it, or coerce you to go to trial and not accept this plea?
No, Your Honor.
Did anyone promise you anything that caused you to reject this?
No, Your Honor.
You've had no time to speak about this with your attorney?
Yes.
And you understand the varied consequences. If you are found guilty of carjacking, it's life range term of years, but not less than 25. I can do 50 or 100. I mean, there's no restriction on that. You understand that?
Yes, ma'am, I do.
And there'll be sentencing guideline recommendations. Has anybody run the guidelines to look at the difference?
I think we have, Your Honor.
All right, and so you discussed all of that with your attorney.
Vaguely, yes.
Well, so under this plea agreement, you would get 15 years up to whatever, up to, so I would determine life, because it would be up to life, but it'd be 15 years on the minimum as long as things went well. So you
Yes.
understand you're facing, there's quite a big difference between
Yes, ma'am.
taking the plea and going to trial.
Yes, ma'am.
And there's a presumption of innocence. I'm not saying that you're guilty, I'm just saying, I just want to make sure that you have weighed all the various options.
Yes, ma'am.
Okay, and it's your wish to go to trial and reject this,
Yes, ma'am.
and you made that of your own free will,
Yes, ma'am.
and no one promised you anything.
No, ma'am.
And you did that after you spoke with your attorney,
Yes, Your
and
Honor.
you've been satisfied with this representation,
Yes, ma'am.
and we have trial dates.
September 25th.
I'd like to make an additional record if I may on
You
some of
may,
these. Mr. Brown, we did discuss this offer before, is that correct?
Yes, sir.
Including not only earlier last week, but down in receiving this morning, is that correct?
Yes, sir.
And you did make a counter offer to the people of 10 years, is that correct?
Yes, sir.
And you do understand that the minimum being 25 years, is that correct?
Yes.
You still wish to enter into go to trial in this case, is that correct?
Yes, sir.
No additional questions, John.
all right, sir, you understand that there'll not be another final pretrial, we will simply go to trial. So there's no more negotiations, and the reason I do that is because at some point there has to be a final decision.
Yes, ma'am.
And if I allowed you to plead in the date of trial, then somebody else would be denied that trial time. So I have to keep things moving that way. So there has to be a cutoff. And so this isn't meant to force you, but you've been here in front of me a number of different times. And we had a number of different final pretrials. So this is the final offer and this is the rejection. We now go to trial. Do you
Yes.
understand that?
Yes, ma'am.
And that's what you wish to do.
Yes, ma'am.
If we're dissatisfied, we'll see you at trial.
Thank you. We'll make sure you guys trial, folks.
Thank you. Yeah. So. clerk.
I'm fine with that, I just don't know for this past year, so.
What is it?
It's 12:10.
No, what is it? Okay.
Will be a final pre-trial that will need a brief adjournment on. Can you bring out Reichstetter? Sorry. Let's see.
Do you want to go page lost? Sure.
Anthony Reichstetter, Your Honor.
This is docket 261894FH, People of the State of Michigan versus Anthony Reichstetter. Counsel, your appearance for the record.
Good morning, Your Honor, or good afternoon, Your Honor. APA Bart Buxton on behalf of people of the state of Michigan.
Reverend Jeffrey Kaplan, P 74943, on behalf of the defendant who's standing to my right.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes.
Thank you. Have you taken any medication yesterday or today?
No.
Are you supposed to be on medication you're not on?
No.
Any sign of fever, COVID, or other illness?
No.
And you've had enough time to speak with your attorney?
No.
Would you like more time?
We just spoke a couple days ago. Oh, I guess a couple days ago.
Or would you like more time today?
No, I think we're pretty good actually right now.
All right, counsel, what are we doing here today?
Yes, Your Honor, today's the date and time set for the final pre-trial. However, the negotiations in this case were involving mental health court. I was just informed yesterday that Mr. Reichstetter is not able to do mental health court here in this county as he lives outside of the state lines. Therefore, we would be asking for a brief adjournment, or sorry, not state lines, county lines. I apologize. So we would be asking for a brief adjournment so we can look into, and I believe he lives in Eaton Rapids, so we would be looking for potential mental health court in Eaton County.
Okay. Let's, I don't know what their backlog is, but how long has he been in custody? How many weeks have you been in, sir? Do you know?
It was 153 days, so 5 months, just over 5 months.
And are you taking any psychotropic meds?
No,
Have you been evaluated?
no.
Your Honor, I talked to his family, and this is part of the issue. We've had our social worker trying to arrange housing here in Ingham County, as well as looking into possibilities for mental health court. Because of this, there is a family history of mental illness, although he's not been diagnosed.
So were you diagnosed as a kid?
No,
Do you think you have issues, sir?
I think I'm okay.
I've spoken to his, sorry, Your Honor.
And it's just, well, I'm wondering, is there an issue where we need to send him to forensics? I mean, I'm not a doctor, he seems perfectly fine to me, but I don't know, a mental health court may help him with other kinds of issues, trauma or what have you, so I don't know what's going on, but.
Yeah, and I have talked to his family. two of his sisters, his mother or his aunt, I forget. They all believe that he's got issues that need to be addressed psychiatrically. And again, there's a history of mental illness in the family. I have to look at my notes again. I believe his father was bipolar. So that's why we were looking into it, Your Honor.
All right, so here's what we're gonna do. I'm gonna give you a date, but meanwhile, I'm gonna have community mental health or somebody get in there. It's difficult to get into mental health court on a, well, he might need to go there, but we think he has a history, but we don't know, and he looks perfectly fine and looks to me like he can handle his, conversations, but I don't know how he is throughout the day. But community mental health somebody needs to go in there and do something, or you're not getting into any mental health court. I mean, they're backlogged, so let's do some preliminary work. So how about we, give you a date? I'm just gonna give you a date now, October 7th. Is that enough time for you to figure all this out?
Yeah, Your Honor, I've got my
Great.
social.
October 7th at 10 for our final, whatever, we're just gonna do a continued pre-trial.
Okay.
And that's fine, Your Honor. If mental health doesn't work out, we will have the continued negotiation.
Actually, since I'm just gonna do a continued pre-trial, let's just do that at 9 o'clock. And then we can always do a plea or whatever we need to do at 9:30 or whatever, after you've had time to talk. Let's just do it that way.
All right. Thank you.
Thank you, Your
Are
Honor.
you getting what you need at the jail? Yes?
Yeah.
Okay, so I ordered community mental health to go in there and talk with you. I don't know if there's any other evaluations. Mental health is a good resolution if you need it, and it might be that you don't have a diagnosis, but maybe there's some trauma that needs to be addressed that would be useful for you to go through the mental health court. So you work that out with your attorneys. There's no stigma attached with it. It's a really good program. So I don't know, but we'll talk further October 7th. I just need you to cooperate then with your family if there's any history that might help move this along. Maybe you want to sign releases or allow them to talk to your mom or your aunt or whoever. I don't know. Does that make sense?
Yeah, I understand that, yes.
Okay, so you and your attorney and the social worker can do whatever, and if I need to sign anything, let me know, okay?
So, Your Honor, when you said you're ordering community mental health to do that, is there anything we need to do on our part?
It's gonna be in the court note,
Okay.
but, it might be that he or his mom, he needs to sign a release so mom can talk, or, all that stuff. So I'm just wanted to have that chat with him, and then if I do need to sign something further, please let me know, or if we need to move this back so we can get an evaluation, because turnaround time might be too short for community mental health or whatever, let me know.
I guess what I'm asking is the court gonna let community mental health know that they need to interview
It's gonna
him?
be in the court notes of the jail.
So that, okay.
Jail has an
gotcha.
interest in moving him out and getting all that, but
Okay,
if I need to do something to help it out further, please let me know.
excellent. Thank you, Your Honor.
Thank you.
but we have Mr. Buxton first.
I'm sorry?
Wait, Mr. Buxton, I.
Yes.
We don't have reset same be done. We got two defendants that are leaving on that. We don't have that. So maybe we should take the break. I would agree. So maybe we'll-
We have break.
Yes.
Actually, when we're
Not send Golden Brown on the bus. There's some negotiation.
I believe we're on break for now.
Like a lunch break?
Yes,
Like half an hour.
half an hour, okay.